Every divorce case is unique, and some can be complex. What follows is a very basic overview of divorce law and the issues to be aware of. There are several ways to obtain a divorce in Pennsylvania. The most common is a no-fault divorce, which simply means that the reasons the parties are getting divorced are irrelevant. There are two types of no-fault divorce. The first is by mutual consent, where the parties agree that the marriage is irretrievably broken. The second is where only one of the parties wishes to pursue the divorce without the consent of the other party. The difference between the two types of no-fault divorce is the waiting period. If it is by mutual consent, the waiting period is only 90 days. On the other hand, if only one party wishes to pursue the divorce without the consent of the other party, there is a minimum 2-year waiting period from the date of separation. Generally, the other way to obtain a divorce is through fault grounds. There are several fault grounds, the most common of which is indignities. Indignities exist where one spouse has made the condition of the other spouse burdensome and intolerable. Additionally, the spouse alleging indignities must prove that he or she is innocent and injured. The grounds for a divorce are determined after a hearing on a case-by-case basis. It is important to note that the economic settlement of the case has nothing to do with whether or not there is a fault divorce or a no-fault divorce. Hearings may still be required, even in a no-fault divorce, to determine and resolve the economic issues of the case. Despite the fact that the parties may agree upon the divorce, the division of assets can become a contested component of the case. Here are some divorce basics. Assets can be a primary focus of a divorce. Generally, all property acquired by either party during the marriage and any increases in values of non-marital or premarital items will be considered marital property. However, there are exceptions to this rule, and if applicable to your case, we will discuss these. Marital property is divided between parties without regard to marital misconduct, in such proportions and in such manner as the court deems acceptable after considering a number of relevant factors, including things such as the length of the marriage, any prior marriage of either party, the age, health, and income of each of the parties, the contribution by one party to the education, training, or increased earning power of the other party, and generally the most important factor is the earning capacity of each party. If the parties are unable to agree to a division of the assets, a divorce master will be appointed to hear divorce and equitable distribution issues. A divorce master is an attorney appointed by the court to serve in a judicial capacity. A divorce master can assist the parties in moving towards settlement by requiring disclosure of all the assets, or can schedule hearings to determine by court order how the marital estate should be distributed. There are many issues that arise in a divorce and equitable distribution matter that must be appropriately considered. Communication with your attorney to guide you through this process is critical. Entering into negotiations with a clear understanding of your rights based on the law and your understanding of what is in your best interests eliminates the variables that would be left open and vulnerable without the careful attention of an experienced attorney. Make no mistake, divorce can be a legal minefield with a lot at stake. Trust and reliance on an attorney's advice is essential. We hope that this brief overview will provide you with some insight into what lies ahead. We at CGA Law Firm appreciate the difficulty of considering divorce, and we look forward to serving you in a personal, professional, and efficient manner.